Hi, my name is Cara Cookson. I use she, her pronouns, and I'm with the Maine Office of the Attorney General. And this is the Ethics and Confidentiality session for the Maine Victim Assistance Academy. And I'm joined by Kayce Hunton.
Hi, everyone. My name is Kayce. I use she, her, they pronouns, and I work as the intervention coordinator at the Maine Coalition Against Sexual Assault.
So for today, we are going to work on developing an understanding of the ethics that guide and inform the supports and services available to victim survivors here in Maine. We're going to work on our understanding of the confidentiality provisions that apply to different roles because we have many different roles that are represented among our Academy participants. And think about how to access ethics and confidentiality information that's specific to your respective role in the future. Ethics is a practice. It's something that we should be continually learning about and thinking about. And likewise, the confidentiality provisions that apply to different roles can change over time. I'll hand it over to you.
All right, thank you, Cara. So the first part of our presentation will be focused on ethics, and we're going to talk about ethics by defining ethical standards, discussing how personal values can impact ethical decision making. We're going to identify some key ethical standards for advocates and discuss where you all can find ethical standards and get support. So let's start out by defining ethical standards, which are also sometimes referred to as ethical commitments or a code of ethics. And although there are many different definitions available, the Office of Victims of Crime, OVC, defines ethical standards as ethical standards identify behavioral expectations of advocates based on the core values of their respective field or role. So ethical standards support survivors and they support advocates. And the ethics in survivor advocacy are also critical to services being safe and empowering for survivors and supportive of their unique healing process. The nature of survivor-centered advocacy work is that advocates don't work from scripts or formulas. You know this. Rather, advocates take the survivor's lead and you all strive to support them in their self-identified needs. And because advocates are likely to encounter new situations where they need to make decisions, sometimes in the moment, that are reflective of whatever they're presented with, ethical guidelines are there to help advocates provide safe and empowering services. And it's also important, and I may say a couple of times throughout this presentation, that support and supervision is available to you. It's really important that you know how to access that and to get help in navigating some of these tricky ethical standards or ethical situations. So, why do ethics matter to us? They matter for a variety of reasons, such as they address areas where problems have arisen or may arise. They help demonstrate values. They protect those seeking services. They create transparency, and they help with decision making. And in addition to the list on your screen, I think it's important just to mention that the Office of Victims of Crime Ethics in Victim Services training also talks about that advocates care about ethics because a code of ethics for a profession also safeguards the reputation of that profession, and it really furthers the competent and responsible practice of that profession. So in the outline, I said we would discuss how personal values can impact ethical decision making. And both in the definition of ethical standards we reviewed together and in talking about why ethics matter, the word values was mentioned. So let's talk a little bit about how values intersect with ethics and ethical decision making. Values are the ideals or beliefs to which an individual or group aspires. Morals relate to making decisions between right and wrong. And ethics is the articulation of standards of behavior that reflect those values or morals. So, to reframe that, essentially, ethics describe in writing the standards of how we will act in our various roles to reflect the values and morals of our profession. There are some key values in victim assistance. And although values may vary depending on your specific role, these are some of those key values. So, competence, which involves knowing your capabilities and hopefully exercising those capabilities at the highest possible level. But it also involves being aware of where we have limitations and areas in which we need to grow. Integrity, which encompasses honesty, fairness, and respect. Professional responsibility, which includes maintaining professional standards of conduct and encompasses communication and collaboration. Respect for people's rights and dignity, which encompasses the commitment to rights of privacy, confidentiality, and self-determination. Concern for others' welfare, which includes advocates not abusing their position or misleading people. And social responsibility, which includes a commitment to reducing crime and victimization. So, regardless of your specific role and regardless of the specific ethics that guide your respective profession, many of your ethical standards will be built on these key values. All right. So, personal and professional values and how those intersect. So, professional values grow from the same basic desire as personal values: do no harm, help others, and make the world a better place, which is why I suspect we're all doing the work we're doing today. But personal values and professional values have a different focus. Our personal values really encompass our whole lives, and they've been with us long before we started doing our work. And our personal values also might morph and change depending on our relationships, our growth, and our personal learning and our life experiences. So it's important to be aware of our own attitudes, our own biases and beliefs, and how those affect our responses to victims of crime and to the ways we're expected to do our work. Because any conflict between a victim service provider's personal and professional values really could affect ethical decision making. And in some cases, it could compromise the advocate's ability to serve effectively in a particular situation. There are some common ethical issues that can come up and are areas that are potential conflict between an advocate's personal and professional values. So boundary issues, confidentiality, legal advocacy versus legal advice, and professional competence. And advocates are really encouraged to do a self-inventory, whatever that might look like for you. And that self-inventory would be of your own personal morals and values in order to really better understand where any conflicts may arise with your professional values and ethics. And again, it's so important to have support and supervision to help navigate tricky situations. So I just want to recap our definition of ethical standards. So again, ethical standards identify behavioral expectations of advocates based on the core values of their respective field or role. And although, as you've heard, ethical standards are going to be different depending on what type of advocate you are and what organization you work within, there are common themes in victim service ethics that are based on those key values we just talked about. So honoring client autonomy, privacy and self-determination, objectivity and abstention from abuse, honesty, equity of service, compassion and respect, social responsibility and confidentiality, and then working within one's range of competence. There are going to be times where you'll need to recognize and respond to potential ethical conflicts in your professional role. And the Office of Victims of Crime offers a 6-step decision-making process for when you're faced with needing to potentially make some really tough decisions. So the first step is to assess your information, review all the information you have. The second step is to kind of identify any of those relevant ethical standards that you might be working within, and then also identifying practical considerations. And practical considerations really means the experience, the real life situations or real life actions that have happened or might need to happen. And then to kind of step back and think about what ethical standards and corresponding practical considerations might be in conflict. So to continue with the 6-step decision-making process, the third step is to brainstorm several courses of action and the potential outcomes of each of those actions. The fourth step is to consult peers or supervisor. The fifth step is to choose the best option and act. And then the final step is to evaluate what could have been done differently, maybe what could have gone better, and maybe how the situation could be avoided in the future. I think it's also important to point out that this 6-step process may indicate that one has a lot of time in this decision-making process. And the reality is that we know that sometimes really hard decisions need to be made in a fairly short period of time. So this is some guidance and maybe a way to practice that difficult decision-making. And also we want to acknowledge that you might have to just do the best you can in the moment, choose the best option in the moment, and then come back later and maybe go through this process, particularly the evaluation phase. So there are some important things that advocates should never be doing. Advocates should never talk to anyone without the consent of the survivor. We're going to come back to that one in a moment. Advocates should never provide legal advice or share details of a case with other system providers outside of the scope of a time-sensitive release of information. Advocates should never answer questions on behalf of the survivor or answer questions outside of the scope of their role or on behalf of a systems partner. Advocates should certainly never take possession of evidence, tell survivors what to do, or tell other systems partners what to do. So I said we'd go back to the first one. Advocates should never talk to anyone without the consent of the survivor. Well, there's an asterisk there for a couple of reasons. The first reason is because it could be a situation of mandated reporting to Child Protective Services or Adult Protective Services. And in those cases, you'd be obligated to make that report, and you may not have the consent of the survivor to do that. And the other point is that consent may be obtained in a variety of ways, and it will be important for you to refer to your agency or department's specific protocols around this. For some advocates, consent, written consent may be required. Cara has shared with me that for victim witness advocates, there's consent if the victim witness advocate has carefully explained the limits of confidentiality ahead of time, and the victim therefore consents to speak under those terms. So respecting confidentiality is such an important part of ethical standards, and Cara is going to talk more specifically about confidentiality in just a few minutes. There are some specific ethical standards for advocates, and these are some specific standards that may apply to individuals enrolled in this academy. So there's the National Advocate Credentialing Program Code of Professional Ethics for Victim Assistance Providers. There's Help in Healing, a training guide for advocates, and that's specifically for sexual assault advocates. There's Core Comprehensive Advocacy, Intervention, Response, and Ethics training for domestic violence advocates, and there are the main rules of professional conduct. Here are some additional resources for advocates, some places you can find more information. You can certainly always contact Cara or myself with any questions. In addition to this list, because this list could have been a lot longer, the National Association of Social Workers has a code of ethics, as well as the American Counseling Association. And really, most social service or victim service professionals have ethical standards or codes of conduct. And this is important for you to know, particularly as you support survivors and families as they navigate services and resources in the community. Because again, going back to the beginning of the ethics part of the presentation, ethics and ethical standards really exist to protect you all and to protect the people you're serving. So with that, I'll turn it over to Cara.
Thanks, Kayce. So we're going to focus in now on the concept of confidentiality. Big picture, one of the reasons why confidentiality rules exist is because the creation of confidential relationships, these legally, helps to foster trust. So we have rules of evidence, for example, that create attorney-client privilege that we're going to talk more about. And the value that underlies that concept of attorney-client privilege is the idea that we want clients to be able to say what they need to say to their attorneys in order for that relationship to function properly. So, big picture, I think what you should have in your mind is this idea of we want to support confidentiality and promote confidentiality as much as we can within our role to create trust, both in the advocate to victim survivor relationship, but also trust between the victim survivor and our office or agency as a whole. And I think another issue along those lines is just to suggest that even if the rules allow for more sharing of information, I think sort of morally, ethically perhaps, it's important to avoid sharing information among colleagues, let's say, that you don't necessarily need to share. I'll give you a VWA example. Something that can happen in a prosecutor's office is a crime happens and other members of the staff are curious. What did the victim survivor say? What do they think? And Ethical practice would suggest that even though the confidentiality rules allow for that information to be shared because the other staff member is within the prosecutor's office, that's not a good idea in terms of protecting that person and their information and respecting their dignity and their desire to keep that information privileged and confidential. So that's something to keep in mind in terms of how we conduct ourselves to really to go above and beyond what's required where we can, because in the long run it can help to foster trust and support the quality of relationships that we want so that we are most effective working with victims and survivors. Another really important concept, because there are exceptions, all of our professions have exceptions to our confidentiality rules. It's really important to make sure that we don't have unmet expectations, because unmet expectations about what is and isn't confidential can cause re-traumatization. When someone has that experience of saying something and thinking that it's going to be private and then it's not, that can be really harmful. So you want to explain the boundaries that you have within your role right up front. Seek consent to have that conversation based on the boundaries that you've laid out, and you're going to need to repeat that often. One of the features of working with someone who's experienced trauma is that it can be difficult to take in information and remember. And so one of the things that I see victim witness advocates do, some of them, is they will include right in their signature of their email what the boundaries of their confidentiality are, so that it's easy for a victim survivor who might be communicating via email to get that little reminder. There may be some things that need to be disclosed. Another thing that's really important, and we talk about this in ethics generally, is to consult with your colleagues and supervisors often and touch base where you may have issues that arise that concern confidentiality. And also to regularly revisit your agency or organization's policies and procedures and think about whether they are fully encompassing what the rules require. And again, are there opportunities to go above and beyond as well and do more than what the law or the rules require to protect people's privacy and respect the things that they're willing to share. And then another great best practice is, to the extent that someone has given consent or signed a release of information, it's great practice to document when a release has occurred, whether it's written or maybe there's sort of an oral consent in a non-community-based advocacy setting, and also to document any disclosure. So we gave this information to so-and-so, or we called so-and-so and shared X, Y, and Z, so that it's very clear what information is allowed to be released and what has been disclosed. Okay. So this will look familiar from the early sessions of the Academy. Our roles, community-based roles, system-based roles, and the confidentiality and privilege provisions that apply to them sort of lie on a spectrum. So generally speaking, the more community-based someone's role is, the more strict the confidentiality rules are going to be. And the more system-based someone is, let's say someone who works for DOC or someone who works for a prosecutor's office, the more exceptions we're going to see to the confidentiality and privilege provisions, sort of the more required opportunities there might be for where things have to be disclosed. So I just put this up again to sort of remind everyone of those concepts. So the first type of privilege that we're going to talk about is attorney-client privilege. And we do have some attorneys in our group, but also I think it's important to understand how attorney-client privilege works, especially because when we're talking about attorney-client privilege, the attorney, so to speak, includes both the lawyer and the lawyer's representatives. And so technically, employees of a prosecutor's office are the lawyer's representatives for purposes of attorney-client privilege. Now, this doesn't come up very often because for prosecutors' offices, the client is the state. But I just flagged this to say that there are these provisions, and there's a related provision we won't talk about as much today called work product privilege that can come into play for the lawyers that victim witness advocates may be working with. So there are two sets of rules that complement one another that apply to lawyers and lay out attorney-client privilege. One is the main rule of professional conduct 1.6, and that's what requires lawyers to protect their clients' confidential information. And then there's the main rule of evidence 502, and this is what allows the attorney to protect that information in court. So evidence rules are going to govern what can and can't be admitted both in civil court and in criminal court. And 502 is one that sets out what's called the attorney-client privilege. And so generally speaking, attorney-client privilege is the idea of a communication between a client and attorney being protected, so long as it's a confidential communication. And what that means is, and this gets to our first exception, it can't be something that's already been disclosed. So attorney-client communications aren't protected if it's information that's already been disclosed to someone else, if that makes sense. Or if there was a non-attorney involved in that communication, that can sometimes sort of breach that privilege. The other exceptions that apply are exceptions that allow the attorney to make disclosures, but what's interesting with attorney-client privilege, as opposed to some of the exceptions that we'll see for advocates, is that the language says may. So attorneys aren't required to disclose, but they're allowed to. They can without breaching their professional ethics. And that is situations where making a disclosure could prevent reasonably certain substantial bodily harm or death, right? So they have a reason to think based on the client's communication that somebody could be seriously harmed or killed. Or to prevent a financial crime or fraud. There's also a related one that has to do with repairing financial crime or fraud. And then the other may opportunity is to comply with another law that may exist or comply with a court order. And that theme of court order carries out in some other areas as well. So for our what are called non-governmental advocates for purposes of Maine's privilege statutes, and by that I mean domestic or sexual assault community-based advocates, and that includes our tribal programs. There are a couple different provisions that are going to apply. So as we've already talked about today, these types of advocates are mandated reporters for purposes of reporting either suspected or likely abuse or neglect, or the fact that a suspicious child death has occurred. So this is one of the big ones, and you can get a whole mandated reporter training. So this is just touching on that idea today, but this is the big exception for our non-governmental advocates, that they are mandated reporters, and so to the extent that they become aware of this type of information having to do with child abuse or neglect, they need to make a report. Other than that, by statute, there's a pretty substantial privilege provision that applies to our community-based advocates. So it protects both confidential communications, but also documents and other items that may be shared with the advocate. And there are just these limited exceptions. So always the victim can grant permission to disclose. And we'll talk a little bit more about what that would need to look like based on some federal requirements. And this applies to civil and criminal court testimony. It also applies to subpoenas. So you can't require an advocate to testify at a deposition or provide documents in let's say a civil lawsuit or a child protection proceeding, something like that. And again, the only other exceptions are the mandated reporting, or if there was a court order, and the standard is pretty high to prevent a court order from coming into play. So that scenario is pretty rare and unlikely. And then, as I said, there is this overarching federal provision that applies to those who are funded with Violence Against Women Act funds. And if you are funded through this program, then you have this broader confidentiality provision, and it's going to require a written, informed, and time-limited consent to release of information. And the only exceptions are if there was a statutory requirement or court order. And again, there's so much more information specific to this topic for our community-based advocates. And so please seek out your supervisors and your office policies to have clarity on this, but just to give everyone a general sense of what this looks like. Again, if we look at that spectrum, these are the folks who have the most strict guidelines that apply to them. Now we're going to talk about our governmental advocates, and our provision in Maine is actually specific to victim witness advocates. And this, again, does establish a privilege. As a general rule, communications between a victim witness advocate and a victim survivor are confidential, and likewise, documents or other materials that have been given to the victim witness advocate would also be considered confidential. And that's the general rule. The difference is that there are more exceptions. So as always, the victim can grant permission to disclose, and that's explicit. There is a mandated reporting exception, although whether mandated reporting specifically applies to VWAs, different question and something to discuss in a different training. There is a court order exception. There's this notion of a prosecution exception. So the information can be shared sort of within prosecution or with law enforcement in order to further prosecution. And then there is what's called the exculpatory evidence exception. This is the big exception. This is the one that comes up the most often. And so prosecutors are required, as a matter of their ethics and as a matter of court rules, and as a matter of the defendant's constitutional rights, actually, to disclose any information they have which might show, and that's a very broad might, which might show that the defendant is not guilty of the offense. And so this is the exception that can come up most often. And and it's not a decision that a victim witness advocate can make themselves as to whether or not something is exculpatory. This is a decision that's made by the prosecutor assigned to the case to determine whether or not something has to be disclosed, again, as a matter of the defendant's constitutional rights, as a matter of that prosecutor's ethical responsibilities. And so, again, knowing that that exception exists, what victim witness advocates are very careful to do early on when they're speaking with victim survivors is to help them understand that not everything they say can be kept confidential, especially if it could possibly be used to show that the defendant is not guilty of the offense. The other provision that applies in this setting is one that protects the current address or location of victims if the prosecutor suspects that there is a substantial risk of harm. And that standard it's very discretionary to prosecutors. And you will find that many prosecutors, just as a matter of course, will protect victims' current address or location from defendants. and it's incumbent upon the defendant to file a motion to try to obtain that information to the extent it could be relevant in the criminal case. But often it's not, or the defendant already knows the current address or location, and so it doesn't necessarily need to come up. But I think this is also a really important provision that protects confidential information for victim survivors, and something for everyone to be aware of. And so from there, we have now concluded our walk through ethics and confidentiality. Again, broad brushstrokes, giving you a general sense of what you need to know. And we hope that you will reach out to either my program at the Attorney General's office, which supports victim witness advocates, that you'll reach out to our three coalitions here in Maine, MCDV, MICASA, Wabanaki Women's Coalition, that support our community-based advocates. If you have any questions at all, we're here to support you in ethical practice. Any follow-up, Kayce?
No, thanks everybody very much for watching, and hope you have a great day.